Today, we're going to break down a truly fascinating Supreme Court case. It's a perfect example of what happens when traditional, old-school laws are forced to adapt to modern digital spaces. We're looking at the landmark case of Ang v. Court of Appeals, that's GR No. 182835, decided back on April 20, 2010. It's a case that really tests the boundaries of privacy, technology, and our justice system, and it asks a fundamental question about how we even define harm in the age of digital communication. So let's kick things off with a pretty provocative question. Can a single text message actually be considered violence against women? Usually when we hear the word violence, our brains instantly go to physical acts, right? But as technology evolves, the ways people can inflict harm evolve right along with it. This case really challenges us to look beyond just the physical and understand the heavy psychological weight of our digital actions. The whole case really boils down to this intense contrast. On one hand, you have the action itself, a digital action that literally took mere seconds to execute. The accused pasted the victim's face onto a picture of a nude woman and sent it to her via MMS. But on the flip side, you've got the victim's reality. The victim, Iris Sugod, suffered profound emotional anguish, humiliation, and deep psychological distress. So the Supreme Court had to weigh this tiny digital snippet against a very real, absolutely devastating human impact. To really unpack how this all played out, we've got a 5-part roadmap for this explainer. We'll cover the digital harassment case itself, how the law defines a dating relationship, the single-act defense, a tricky question about electronic evidence, and, finally, the Supreme Court's ruling. All right, let's jump right into Part 1, the digital harassment case. The facts here are stark and honestly pretty shocking. The accused, Rustan Ang, was charged under Republic Act 9262, which is the Anti-VAWC Against Women and Their Children Act. His crime? Sending that humiliating, manipulated MMS to his former girlfriend. Now, he was actually convicted right out of the gate by the regional trial court for violence against women, specifically for inflicting psychological distress. But Rustan Ang wasn't having it. He appealed to the Court of Appeals, and eventually this legal battle made its way all the way to the Supreme Court. Which brings us to Part 2, defining a dating relationship. Now, one of the first things the accused tried to argue was, hey, we aren't together anymore, so this law shouldn't even apply to me. But if you look at Section 3A of RA 9262, the text is incredibly clear. It explicitly protects women against whom an offender has or had a sexual or dating relationship. That past tense had is absolutely crucial here. The law recognizes that a person's vulnerability doesn't just magically vanish the second a relationship ends. Basically, Rustan Ang brought this specific checklist of defenses to the Supreme Court. It was like a legal puzzle he built to systematically dismantle his conviction. He claimed 1, there was no dating relationship under the law. 2, his single text message didn't qualify as a quote-unquote series of acts. 3, the electronic evidence violated his constitutional rights. And 4, that obscene pictures shouldn't have been admitted into evidence at all. The Supreme Court had to knock these down one by one. Let's tackle that second point in Part 3, the single-act defense. The accused threw out what you might call a straw man argument here. He essentially said, look, sending that nude picture via MMS was just a single isolated act. His logic kind of assumed that harassment inherently means pattern, and therefore a single text shouldn't trigger the heavy penalties of the Anti-VAWC Against Women Act. It's a clever argument on the surface, right? Does a single click of the send button equate to violence? Well, the Supreme Court completely dismantled that defense. They didn't get into some deep philosophical debate about the definition of harassment. They literally just pointed directly to the text of the law itself. RA 9262 explicitly says it covers any act or a series of acts. The word act is singular. The court ruled that even a single isolated incident, if it results in psychological harm or distress, is fully sufficient to constitute violence against women. The severity of the emotional impact entirely outweighs the frequency. Let's shift gears to Part 4, the electronic evidence question. This is where the accused threw a massive legal curveball. He tried to claim his constitutional rights were violated because of how the digital MMS evidence was admitted into the court record. He leaned heavily on something called the rules on electronic evidence, basically trying to use a procedural technicality to block the MMS from being seen. But the court systematically broke down this roadblock by looking at the exact scope of those rules. The Supreme Court's ruling on this was absolutely decisive. They clarified with total authority that the specific rules on electronic evidence the accused was relying on simply do not apply to criminal actions. Since this was a criminal prosecution under RA 9262, the rules he cited were literally irrelevant. The picture was properly admitted by the trial court, and just like that, his constitutional rights defense totally crumbled. And that brings us to our final stop, Part 5, the Supreme Court ruling. So what was the final verdict? The Supreme Court firmly, and I mean firmly, affirmed the Court of Appeals decision. They found Rustan unequivocally guilty of violating RA 9262. The court concluded that the prosecution had successfully proven every single element of the crime beyond a reasonable doubt. That single MMS, the deep psychological distress it caused the victim, and the context of their past dating relationship, it all aligned perfectly with the letter of the law. To wrap up this explainer, I want to leave you with a bit of a provocative thought. This case from 2010 was a massive stepping stone. It proved that psychological harm inflicted through a tiny phone screen is just as punishable as physical harm in the real world. But think about how fast technology moves. As our lives become even more tangled up in the digital world, with social media, deepfakes, and instant messaging everywhere, how else is our justice system going to need to adapt to protect our personal privacy and our mental well-being? It's definitely something we all need to keep thinking about. Thanks so much for joining me on this explainer, and keep questioning the world around you.